Good afternoon, everyone. Okay, we're here for the session on managing notorious trials in the media spotlight. My name is Paula Hannaford-Agor. I'm the director of the Center for Jury Studies at the National Center for State Courts. And I'm here this afternoon with three very distinguished panelists to talk about what it is in terms of thinking about managing notorious trials. Let me introduce, first of all, our panelists. To my left, your immediate right, is Judge Joseph Kreamer, and he is from the Maricopa Superior Court here in Phoenix. He is the associate presiding judge for the criminal division. And unlike what you might see in terms of some of the background materials, he is with the Superior Court of Arizona. He is not a justice on the Arizona Supreme Court. But he has an extensive amount of experience dealing with notorious trials. He'll be talking about a couple of them. There is a notorious trial that is going on currently here in the Maricopa Superior Court. Some of you may have heard the name Jodi Arias. They're getting ready to redo the sentencing phase of that trial. We will hear a little bit about that case. Unfortunately, because it is a pending case, we're not going to hear probably as much. But Judge Kreamer has a lot of experience in other notorious trials, and so has a lot of wisdom to bring to this. Next to Judge Kreamer is Judge Jackie Glass. She is now retired, but was a district court judge in the 8th Judicial District in Las Vegas, Nevada. And she is most known for being the trial judge in OJ3. This was the robbery case. And interesting, in getting that case, she also has a very interesting background. Before she became a lawyer and went on the bench, she was actually a broadcast newscaster. And so she actually could see it from both sides of sort of what is the media looking for and what is reasonable expectations on the part of the media and what are unreasonable expectations on the part of the media. And then finally, to my far left is Judge Belvin Perry. He is the chief judge in the 9th Judicial Circuit in Orange County, Florida. This is Orlando, Florida. He is probably his most recent, he's had a number of notorious trials, but his most recent one is one you probably remember is the Casey Anthony trial that took place there. So we're going to be talking about all of these different types of trials. There's a lot of really good material out there. How many of you have had a notorious trial in your court? Just raise your hand. So a few of you. How many of you have a notorious trial that's coming up? Anyone? Okay, we got a couple. Notes to take. There's some really excellent materials that have been developed over time. The National Center has some of those materials. There's materials that they have shared about their trials that are up on the conference website. And so I urge you to go to those. This afternoon, we're really going to be talking about and thinking about some of the sort of sideways things and unusual things that you might not think about, and spend our time there. And so just to get us started, why don't we sort of start out with the beginning of the trial and during jury selection. And Judge Glass, I'd like you to talk about, because you had an interesting experience with just using questionnaires and using questionnaires in terms of the jury selection in the OJ case.
We had to spend some time before we actually got started with the actual trial trying to weed out the people who obviously had very pro-OJ sentiments and very anti-OJ sentiments. So we used an extensive jury questionnaire, and in the jury questionnaire on the first page, I told the jurors, because my signature was below what I'm about to tell you, that everything they said would be confidential as far as their responses on the questionnaires. So I did not release those questionnaires to the media when they asked. And then when we started the trial on the first day, a lawyer representing Stevens Media and the Associated Press came into court. I was not expecting this at all, and made another demand for the jury questionnaires. And I said no. And I articulated my reasons as being I wanted to protect the defendant's right to a fair trial and also the safety of my jury. I didn't want them tainted. I didn't want anybody to be able to contact them. I didn't want them harassed. I mean, when you're dealing with any of these cases, as you'll hear from all of us, there's so much attention, and you just don't want to lose your jury. So I said no, and that resulted in me being sued, and the decision that is on the website for you all to read, and I urge anybody who has this issue, that resulted in me being reversed by the Nevada Supreme Court, who said that I did not articulate good enough reasons under the case law for keeping those juror questionnaires confidential. So, and one of the things they said I should have done was not tell the jury that they were going to be confidential. Well, when you ask people to sit on cases such as the ones we're talking about, and now with all the attention that they get, people are concerned who are going to be sitting as jurors as to what kind of information about them is going to get out. And a lot of them maybe don't want to participate and would be reluctant to participate and to be open and honest about what they have to tell you. So to encourage that is why I said what I did. Even though I was a former media person, I still said what I did. And if I had to do it over again, I would do the same thing. So be careful with, Judge Kreamer's jurisdiction, we had this discussion earlier, he thought it would come out differently, but in my jurisdiction, it's very open to the press and release everything, and as opposed to what other jurisdictions may experience. But be concerned about how you handle that and what kind of promise you make to the jury. I wasn't going to break my promise unless somebody told me to, and they did. So there you go.
Okay. Judge Perry, in the Casey Anthony trial, you actually ended up not having a jury pulled from Orange County. It was actually from a neighboring county, or not even a neighbor county, about an hour away, I think, right? If you can talk a little bit about that decision, how that came about, and what you did in terms of the media wanting to know where you were coming from, what the rationale was.
Okay, good afternoon, everyone. First of all, this case received a little bit of publicity. The publicity was so sparse that they had a cartoon in the local paper about someone going to the Florida Everglades trying to select jury members. In Florida, you have two options. Both the state and the defense both stipulated for a change of venue. Under our rules of judicial administration, I had two choices. I could move it to a similar location outside of our media group and have the trial there, or I could go under our rules to another location, select a jury there, and return them back to Orange County. Because of the cost involved in shipping all of the witnesses and all of the evidence, I decided it would be best to hold the trial in Orange County in a facility that we were familiar with and had a great deal of control. Once I made that decision, the news media sued me, wanting to know where that location would be. I think they were kind of interested in trying to do the man and woman on the street interviews where they would go around and randomly select people and ask them their attitudes about the case. The District Court of Appeals concluded that based upon the findings that I had made, based upon the notoriety of the case, and based upon the defendant's right to have a fair and impartial jury, that the media did not have a right to know beforehand, as long as I gave them a reasonable opportunity to get there before jury selection. What I basically did was I notified them at 6 a.m. that morning after we knew the jury was there and coming to the courthouse.
Thank you. Judge Kreamer, You actually spend a fair amount of time with your jurors during the jury selection trying to make them understand what's coming and to make them understand sort of the gravitas of the case and what the ground rules are. I wonder if you just talk to that aspect.
Okay, good afternoon, everyone. I think one of the greatest, if not the greatest, challenges you have in a notorious or high-profile trial is with your jury. Jurors today come from a generation where they expect to have access to everything all the time. They expect to be able to communicate with friends, family, with the media, and understand what's happening in the world and be able to see it. My 15-year-old expects to see everything on video within 1 minute of it happening. And those are the jurors that you will get. And when you are in a case that is going to have a lot of media coverage, you need to address with your jury right away the challenges that they're going to have, and you need to get buy-in as quickly as possible. What I tell my jurors right off the bat is that this is a case that will get a lot of media attention. It will be on the news. It will be in newspapers, websites. People will be tweeting about it. We need you to agree that if you are someone that must look at a website, a news website, that must watch the news, that needs to read the newspaper every day, you have to give that up for this trial. Now, at first, jurors sometimes will look and say, okay, I can do that, but you can see it sinking in. And sometimes it needs to sink in over the course of jury selection. You can never talk to your jury enough about the challenges that they will have in trials like this. When I was a young lawyer, in order to research a case, a juror would have to basically go look at microfiche in the library probably to figure anything out. And now all you have to do is take out your phone. And I tell them, don't take out your phone. Don't Google anyone. It's easy to say don't talk to your neighbors or friends about the case, but I don't think that's the greatest challenge anymore, because it's very hard for jurors to resist just looking up something about the case. And so you need to get that buy-in from your jury, and you need to tell them all the time that it's important that they follow that admonition. And I tell them virtually every day how important it is to make sure that they don't do something that's going to put the trial in jeopardy as it relates to social media. And the social media is going to be everywhere.
Just as a follow-up question for that, if you've got a juror who says, Judge, yeah, I'm kind of attached. It's actually a living part of my arm now. I don't think I can do that. Do you just take them at face value and say, thank you very much for your service, maybe another trial, or?
Well, I might, if I'm convinced that they really can't do that. I use basically a combo of a rah-rah speech and a stick with the jury. I start with the rah-rah speech and say, look, jury service is extremely important, and this is a difficult task. These are usually hard cases, putting aside the media. Many of them involve death and mayhem, and they're very difficult cases. But I try and get them to buy into the process and how important it is for them to be there. And then I talk to them about how significant the consequences would be if they can't do it. But I really try and push the notion of, yes, you can do it, and really explore with them. But if I'm convinced that, or believe there's a real possibility that a juror cannot do it, then that juror probably is not going to be able to serve.
Okay. All right. Judge Perry, back to you for a second. In the Casey Anthony trial, you actually had the jurors sequestered for 6 weeks?
6.5.
6.5 weeks. But who's counting?
They were.
I wonder if you could talk, I mean, sequestering jurors, especially for that long of a time, really introduces a lot of complexity, and I wonder if you could just talk about sort of the planning that went into, what were you going to do with these folks for that period of time?
One of the first things you think about is you do not want them to feel like prisoners, because they're going to be isolated and insulated from a lot of things. And you have to make it so that they can discharge their duties, but at least have somewhat of a normal life. Some of the things we did was in the selection of the hotel. We made sure that it was a comfortable place. This was a resort. We worked with the hotel so they could program the televisions. So they had about 20 stations that did not show news. That was fine until the last 2 weeks of the trial when they start scrolling the bylines down to the bottom. Then they only had 3 channels, and that did not make them too happy. The other thing is making sure that they had some type of contact with the outside world. Of course, we removed their cell phones, but in the evening when they got back, they had a time period where they could come into a common area with our court deputies present, where they could call friends and relatives and talk to them. They could also have access to a computer, but it was monitored there because we had one individual that was taking a class online. Some people paid their bills by email. We also had games for them. We had outside activities. We also made sure that they had a DVD library of 200 plus titles, reading material which we all had to review, particularly the lawyers, to make sure that they had no objections. So we did everything we could to make them feel comfortable. And I think that played a big role in us not losing any jurors. In short, you give them the summer camp experience. You give them a packing list, you get their medications, you get everything they're going to need to survive during that 6.5 week time period.
Okay. Now, in both OJ3 and in most of all the cases, you haven't had a sequestered jury here in Maricopa for 30 years. How do you manage the jurors and more importantly, managing the jurors outside, getting them to and from the courthouse, into the courthouse? How do you manage those? Judge Glass.
Well, I feel very fortunate after hearing what these judges are dealing with now, and quite frankly, my hat's off to Judge Perry for how he managed that jury and what he did, because it's an incredible feat. I was in trial in OJ in 2008, and really it was the dark ages, because social media didn't play as big a part as what it plays now. And I think it would be a different story had we been doing it today as opposed to back, 6 years ago? So we just lunchtime sequestered the jury. We had the bailiff pick up the jurors at a particular location, parking. We designated a place for them to park. The jurors were escorted into a particular entrance that was different from the side where the media was, so we kept them separate. We brought in lunch every day from different venues so that they didn't get bored eating, which I know you had that challenge with as well. So that they weren't out and walking around outside the courthouse where, as we all have experienced, all those wonderful people come out who watch these trials with the t-shirts and the buttons and the hats and the signs, the ones that you see regularly on television. So we kept those people, we kept them away from the jury by keeping them in for lunch. And then we had them escorted when we were done at night back out and away from the circus that was happening. So that's how we kept them there. But as far as I had to give them the same admonishment every time and encourage them not to read anything, not to watch TV, not to go on the computer, not to do any independent internet research. It's something you have to continue to tell them over and over and over and over again. And the other thing is, I said, look, if you violate any of the admonitions that I give you, then you're going to have to answer to me, the judge. Most people didn't like doing that. So you just really have to also hope that they listen, and these people are there to do the right thing, which is to serve on a jury, and have some faith in that they will follow your order and they will do what it is that you ask them to do. And you really do. And I think it's even harder to have that now with all the exposure to all the social media that they have now. I think it's a very tough issue for all courts that face this today.
Judge Kreamer?
There is an element of trust that occurs when your jury's not sequestered. I mean, you cannot monitor them 24/7, and that's why it's really important to stay in touch with your jurors. I try and make sure that every day I talk to them about something like this and talk to them about how important it is that they are following the admonition. I will tell them that if something happens and a juror violates the admonition and we have to start over, I tell them, just imagine how much we have to go through. I'm in a trial right now where it took us almost a month to pick the jury, and the jury is screened through the end of August, and I tell them we will have to go through that again. So I give them a little bit of that guilt. I also tell them that there are people that are monitoring social media to see if you are following the admonition. There is a recent ABA opinion, an ethics opinion, about 3 months old, that says that it is okay for attorneys to monitor websites or social media of jurors, and it even suggests that lawyers might fall below the standard of care if they don't do that in certain circumstances. So I tell the jury, look, if you're going to post on Facebook that, hey, I'm down at the courthouse and can't wait to hear more testimony about something, that people are going to see it. And that people do monitor that. So you try and give them a balance of please and we're going to find out and don't ruin this, but it is really difficult to make sure that the jury's not going to see the things that are out there, because they know, they can see it in the courtroom, they see the cameras, they understand, and I'm up front with them and tell them that there's a lot of things going on, but you have to respect the process, and then you just monitor it every day and you talk to them every day.
Okay. Would you hang on to that mic there for a second, Judge Kreamer? I'd like to ask you, when we were talking about sort of these cases, you made an interesting observation about the cameras in the courtroom. And I know some jurisdictions do have, there's an outright prohibition on cameras. Others, it's a presumption in favor of cameras. But you raised an interesting point about sort of how to manage the impact of the cameras.
Arizona is a state that there's a presumption that cameras are permitted in the courtroom. And if we're going to exclude cameras, we have to make certain findings. The first really heavy media trial I did was on what was then In Session or Court TV, and they were great to work with, and I had multiple trials that were on Court TV, and they went very well. And one of the things that Court TV did was not only did they want the one camera in the back, but they wanted a second, or they actually requested to have 3 cameras, but we only gave them 2. And one of them was a robotic camera that sat behind me that they could control. They also set up additional boom mics and basically set up the courtroom to almost be a set, a TV or a movie set, so that they could capture everything. Now, it worked out really well in my trials. I had no issues, and at the end of those trials, I thought, this is fine, because it's really leaving, I think, a good impression with the court, how things are going. They were clean trials. And then the Arias case happened here in Maricopa County. And I was not the trial judge for Arias, and that case is still ongoing. But what I will tell you is this. The experience that we've drawn from Arias, and if you take one thing from this session, I will urge you to not allow the media to have more than one camera in the courtroom, because it changes the dynamic. If you give them one camera in the back, no longer is it made for TV, because just one camera in the back can't capture the defendant's face as he or she sits at the table. They can't capture everything and have that transition that TV needs. And so what we are now doing in Maricopa County generally is you get one camera in the back. We had a case that could have and perhaps should have been just as notorious as Arias in the last few months, the DeVault case, where the facts were really significant. That case got media play, but about 1% of the Arias case, because there was only one camera. And so people following the trial didn't really have anything to watch, and they became bored, even though the facts were just as interesting. And so you can, and I would hope in your jurisdiction, you can at least control the number of cameras. Don't let them have the theater unless you want theater, because that happens when you have more than one camera. One camera in the back, I think, changes everything.
Okay. Jackie?
We too had Court TV come in and pre-wire the courtroom for the OJ case, and I think maybe because it was a different sort of case than yours and Judge Perry's, even though we had multiple cameras, it didn't really have that aspect to it, because I don't know that everybody was looking at OJ's face when the witnesses were testifying to see what his reaction was going to be. So that part didn't really impact us the way it impacted you. While we're talking about working with Court TV and the media, one of the things that really is helpful when you're planning these sorts of trials is to try and be as accommodating as you can with the media, and especially if you're going to be Court TV, but to try and work out a plan and to be as accommodating with them as you possibly can. They're the ones who are putting you out there, and you're going to be wherever, you could be worldwide, it could be nationwide, it could be on every day, it could be streamed live on the web. You're going to be there, whether you like it or not. And if you have a good working relationship, that also, you get a sense of trust, and when you say don't do something, generally they don't do it, and they listen to you. Otherwise, they may lose their privilege of actually being in the courtroom. So it really helped for me to have a very good working relationship with the Court TV people. And then, as you can see from the materials, we developed a decorum order that set forth what they could and couldn't do, and you lay it all out for them, and you have it right in black and white for them, so that there aren't any problems with the media. And I know Judge Perry has an even greater suggestion for those who have to work with the media.
One of the things we did in the Anthony case was we created a media committee. And basically, they set the ground rules, which were approved by me. And they set, if somebody violated those rules, what would happen. So it makes it a great deal easier to conduct a trial and not have any problems with the media if you get them involved, because most of them will have a great deal of influence upon their own colleagues for those who may tend to want to act up. I would strongly urge that you would get them involved.
Judge Perry, before we pass the microphone on, I wonder if you would talk, it's one thing sort of working with the newspapers and radio and television and cable television, sort of those traditional media sources. But now we're in social media, and there are bloggers, there are just internet-based that don't actually, and you really had to deal with that just because of the number of folks that were applying for credentials as media and wanting a seat in the courtroom. Could you talk about how you define a...
Well, as you mentioned, there's your traditional media, television, newspaper, and in radio. And we came up and tried to deal with what we call new media, bloggers, folks who had websites. I believe we had at least 500 people apply for media credentials. And one of the things in working with the media, we came up with a definition of what this new media was. And what they came up with was that they had to have updated content daily. They just couldn't provide links or articles from the past. That it had to be reviewed, that is, their content, by an independent editor, that they had to have readership of at least 1,000 individuals, i.e. hits per month on their website, and that they had previously covered judicial branch. And this was a definition that they came up with after we had looked at a couple of things from NASA and other things. So you're going to have folks that will come and say that they are media. They will have a cell phone with a camera or a small camcorder, and they say, I want some credentials.
I'm lucky in 2008 there weren't that many people that said that they were new media. We did have some, and I do remember giving them credentials We did check them out, and we gave a couple credentials, but nothing like what Judge Perry has experienced.
Okay. I want to just turn now from the media to sort of that broader public issue. Notorious trials can really be a crowd control kind of problem, and how do you allocate seats for, once you've got the media seats and the victim seats and the defendant's family seats, and and then you've got seats for the for the public. How do you do that allocation process and control just the flow of people in the courthouse? Judge Kreamer?
We typically, first of all, we have a great media relations department, and if you can set up a process or a group of people that can interface with the media and interface with security, it's very helpful. You need to have a security conversation with whoever runs security in the courthouse, because it can turn into a situation where people are coming from other cities, states, and countries to watch the trial. We had people flying in from Australia, even understanding that they couldn't get in the courtroom, just to stand outside the courthouse with everybody else to soak it up. And that creates significant security concerns. We work with the media and actually designated a number of seats for the media, and that they would have the same seats, and then open some up to the public, and essentially allowed people to line up, and it was first come, first serve. We have some big courtrooms, and it was a fairly large courtroom for Arias, and I have a even larger courtroom as well, but anything can happen. We had someone actually attempting to sell a seat to the Arias trial, and they got $300 for it before we put the kibosh on it. And so you will have situations where it becomes an event, and people basically are down there every day, and we had people getting into confrontations over seats. And so security needs to be involved, and it needs to be the security people who are involved. Don't make your court staff, unless that's what they do, have to oversee the security. You need your security folks to look at that, and we had special deputies assigned and a special setup so we could address all the numbers that come in. And it's really important that this conversation happens before the trial starts, because if you're reacting to it during the trial, you're going to have problems.
Planning for any of these trials is essential, and the planning starts months and months before you're ever going to go to trial. And when you do this, it's essential that you have your security staff, your office staff, your court administration staff, and anybody that's going to be involved in the day-to-day activities of this trial. You start meeting with them, and you start planning every aspect of this case. Like, for example, the jury services that he did with the jury, I'm sure that they were closely involved. When we were assembling, I think we sent out 400 or 500 questionnaires to get the jury that we did in OJ. So the jury services was highly involved. I had a very small courtroom. I wanted to be comfortable when I did this trial, and I decided I would like to be in my own courtroom because that's where I felt the most comfortable. So I had a limited number of seats that were available to everybody. So we set it up so that each media entity had a seat. We had a lottery for the public seats. We made accommodations for the family. So, I mean, I have a seating chart here that planned it out down to the T, and that's exactly what you have to do here, is you have to plan for just about everything that you can. So we took care of it with the lottery, and actually at the lunch break I heard about there was some kind of funny business with one of the seats that we had. Somebody was paying somebody money for one of our seats as well. But you have, it's the people who are attracted and want to come in when they want to sit in these courtrooms. And if you have a small courtroom or you have a small courthouse, you have to have the planning to deal with it. So you can try and accommodate as many people as you possibly can and keep order, keep it under control.
Judge Perry?
Well, we did it in our large courtroom. We had 100 seats. 50 of those seats were allocated to the general public. The first 2 weeks of the trial, we sort of deferred to Orange County facilities. And to be honest with you, it was a nightmare. People started lining up at 3 o'clock in a certain portion, and then when they went to go to the actual line to get tickets, it was like a stampede.
That was 3 o'clock in the morning, right?
Yeah, 3 o'clock in the morning. And we had a couple of fights break out. But we switched it over. We started passing them out between 3 and 4 in the afternoon. And as Judge Kreamer said, the security people were involved, and it went smoothly. One of the things that we did do was if you did not have a ticket, when you got to the 23rd floor and you did not show that ticket when you got off, you were placed back into the elevator and told to go back downstairs. But you cannot get by without planning. You're going to have to plan every detail and make sure that your security staff is involved.
Before you pass that, stick with you for a minute. One of the sort of odd things about the social media now and the new media and high-profile trials is now we've got sort of this whole cyberspace thing where a lot of impersonation. I mean, who believes everything you read on the internet, right? And so, Judge Perry, I wonder if you'll talk about a little bit, you had both someone impersonating a juror as well as people impersonating you and your court.
Well, there were several Belvin Perry and Judge Belvin Perry websites that were chatting with folk. They were not actually my website. They were a false website for court administration. There was a false Facebook post by someone who claimed to be a juror that really caused some great distress to the defense for a couple of hours before we finally figured out it was not a jury. The best you can do with these websites is you can get the person to place a disclaimer that this is not an actual Judge Perry site. The bottom line is with the social media, be prepared to deal with the unexpected because they will come out of left field with just garbage.
I'm lucky I didn't have anybody trying to be me or any of my jurors, but there were definite like pro-OJ sites and definite anti-OJ sites. It's just the nature of the beast. Like Judge Perry says, you have to be so aware about what's going on and hope that the people who are out there that you're working with keep you informed as to what they see and what they hear, because you want to make sure that particularly your jury, is protected from all of it.
Judge Kreamer, I mean, you had the issue, it's not only thinking about your jurors and sort of the immediate people, but there's real issues now with sort of witness intimidation and other types of sort of almost, real tampering. Is there anything that the court can do to control that?
Well, the short answer is unfortunately not much. We have had trials, the Arias trial, one of them where witnesses have been directly threatened, and it's very hard to unring that bell once it has happened. It's very hard to control the things that people put out there on websites. We had witnesses who had their own websites, they got hacked. We had witnesses who got death threats. That has happened in more than one case. And if the case is going to be televised, I had a trial where there was an order that the witness requested, and I granted his request to not have his face shown on TV because he had sensitive testimony. And so the people watching on TV heard me issue that order, and in-session TV agreed that they wouldn't show this witness's face. So when that occurs, they have the camera trained somewhere else, and sometimes it's on the judge, so they had the camera apparently on me. Well, the witness was sworn in and then walked across in front of me to take his seat. And within just a few minutes, our media relations folks were getting calls and emails from all over the country. I heard Judge Kreamer say that they couldn't show his face, and I just saw his face. And it really had an impact. You could tell when the parties found out that that happened, and it really kind of undermined the safety factor. And so there's not a whole lot you can do. You can issue that order saying don't show that person's face. Now, I've had better luck with that. I've had multiple cases where we've ordered them not to show the face or even record a witness's testimony, and the media does work at that, and you can do that, but people can find out who is testifying, and there's not much you can do about it, unfortunately, in today's world to stop it or to really address the witness's concerns about that happening. The best you can do is try and block it out and essentially hope that it's not too bad for the witnesses.
Now, one of the things that you mentioned to me earlier was the idea of sort of the lag time in terms of televising, because you had an issue with one of your jurors in one of your cases.
Yeah, the other thing that you can do to protect someone, if something like what happened with the witness's face happened in my courtroom today, it should not be an issue, because in a trial that I had a few months ago, it was known as the Buddhist temple murders, the largest mass murder in Arizona history. We seated the jury, and I instructed the jury that there's media, there's a camera, but don't worry, court rules require that the media or cameras not show your face. And so we had the state's opening statement, and as the jury got up to leave, unbeknownst to me, our pool cameraman, and I don't know what he was doing, flashed across and showed the jury for a full 30 seconds. And I was at lunch 30 minutes later, and somebody sent me on YouTube, somebody already posted on YouTube, here's your jury on YouTube. And so I had to go back in and tell the jury, first of all, I apologize, I made a promise to you that I didn't keep, and that's my fault. And I showed them the video that was on YouTube and asked them, are there any of you who now do not want to serve? Does this concern you about your face being out there? And fortunately for me, all my jurors said no, that they were okay. And then I actually kicked the media out of the courtroom and wouldn't let them come back for the rest of that trial. And they did not take it up because I think they realized that there was a basis for that. That case resulted in a mistrial, so I had to retry. So the second time, I did let the media in, but I now impose a 30-minute delay. Not 30-second, but 30-minute. And I require that someone from the media be watching the feed to make sure that the jurors' faces aren't shown, or if we have an incident, there was an incident in Maricopa County where a defendant actually poisoned himself right after the verdict, Michael Marin, and the cameras were rolling, and he poisoned himself, and we had to get the cameras turned off, but it took a while, and there wasn't a delay. So I now have a 30-minute delay and require a media representative to be watching the monitor, the feed, to make sure nothing's going out that shouldn't be going out.
Judge White?
I have a question. How did the media feel about you imposing the 30-minute delay?
They're okay with it. In fact, as part of them trying to get back into the first Buddhist temple trial, they suggested it. And so I said no the first time, but the second time I said I like that suggestion, and we're going to do that. And now the case I have now has a camera, and we're on a 30-minute delay. And they are streaming it on a website just with a 30-minute delay. And the media really it does not seem to be bothered by that at all.
Okay. You've gone through the trial, jury's returned a verdict, and now what do you do with sort of your jurors at the end of the trial? How do you handle that? Because I think in all of the cases that we've talked about, you had anonymous jurors. They weren't known to the media. Judge Kreamer, if you can sort of talk about just briefly, sort of how you handle those issues and what the jurors should know as they're leaving.
Knowing that the media is going to be all over the jury, and sometimes the media sends out what they call bookers to follow jurors home during the trial, and they did that during the Arias case. What we offer the jurors is we say, look, if you don't have to speak to the media, you never have to speak with them, but if you want to speak with them, we will arrange it so you can come right out in the courtroom. The media is all there, and so you can kind of in the safety of the courtroom answer questions. Now, most of the time the jurors say, we want nothing to do with the media and we're not going to do that. But in one of the Buddhist temple cases, the jury foreperson did come out and answer questions, and it actually worked out real well. He was very well spoken. The rest of the jurors stood and watched him answer the questions, and they felt much better about it, and we had little or no media chase of the jurors as they stepped out. So we offer that kind of as a way to maybe blunt the media from chasing jurors out. They will chase the jurors out of the courtroom. The other thing that I've done is that we sometimes arrange for the jury to go out the back door with the sheriff's department down an elevator that the media doesn't know about into an unmarked bus, and we've done that, although the media during the Arias trial got wise to that and just went to the juror's garage and waited for them to show up. So they will figure out a way, no matter what you do, usually to have an opportunity to talk to the jury.
Judge Glass?
We got the OJ verdict at like 11 o'clock on a Friday night. And the jurors could not wait to get out of there. And we, like Judge Kreamer said, had our marshal walk them out down the staff elevator and get them to the garage and get them home. Between that time, and then I released the name of the jurors that evening to the media. Between that time and the weekend, my marshal was getting calls from the jurors telling him that they are being hounded by the media. They are at their front door, they are at their work, they are calling them, and let me tell you, they are relentless. These people are relentless. Nothing stops them. So we put together a quick Sunday evening press conference where we got as many jurors as we could that wanted to participate, because it certainly wasn't mandatory, come back to the courthouse, and we told the press they could all come, and we essentially held a press conference so that we could let the media ask the questions, and that helped. I wasn't going to do it Friday night. The jury was exhausted. They wanted to go home because they had been deliberating all day long. But that really helped to take the sting out of the whole thing, and now that they had talked, the press backed off quite a bit from that. So it really helps, and had I had to do it over, and the timing would have been different, I would have planned it to happen that way so that they wouldn't have been as hounded as they were.
Yeah. Judge Perry, now you had a long delay on announcing your jurors.
We received the verdict on July 5th. And the verdict was read in open court around 2 o'clock. On the 7th day of July, we had a hearing on a motion filed by the news media for the release of the names. Bear in mind that the defendant was represented. The state of Florida, through the prosecution, was represented. But there was no one there to represent the jury. They were basically voiceless. In between that time period, a number of things happened. You could see from the time that verdict was announced, the outrage that was expressed by members of the public and the media. And there were things in the paper like Clearwater Chili Restaurant tells Casey Anthony jury, and they had posted a sign that they're not welcome. There was a juror, Casey Anthony, juror 60, quits work, flees town in fear of her life. She was quoted as saying, "I would rather go to jail than to sit on another jury." There were numerous things that were printed. To say that there were great hostility towards this jury would be an understatement. So what I did was I fashioned an order, citing all of those factors, and had a cooling off period from July, and the names were finally released on October 24th. You know, when jurors sign up, they don't sign up to be part of entertainment. They don't sign up to be members of a reality TV show. they are summoned and asked to be there. The court has, according to our case law in the state of Florida, an inherent duty and power to make sure that those jurors, if the situation dictates, that you take means to make sure you protect their identity. The sad part about it is, unfortunately, with our internet age, if you learn a name of a juror, if someone volunteers their name, they do a Google search and they find them. There were several jurors that when they arrived back in Pinellas County, there were news crews at their homes. So I entered this order, and the news media decided that the better part of valor was to wait to the cooling off period and did not contest the order.
Okay. We've got a few minutes left. I wanted to open it up for questions. Here, let me just.
Question.
Thanks, Dan.
My question is about the cost of these trials. I mean, I can only imagine the extreme cost of them, but to sequester a jury for 6.5 weeks, I would assume was significant. What were those costs? Were you did you have that money budgeted for those purposes already? Did you have to go to your funding authority to get more funding for that?
I knew that the cost would be approximately $360,000. What I did was I got everyone from the clerk's office to the sheriff's department to do a proposed budget. Once I got the proposed budget and I went through it line by line, made sure that there was no fluff involved, I then set up a meeting with the Speaker of the Florida House, who I knew, who was from the Orlando area. I got him on board for special funding. I, in turn, after I got him on board, went to the President of the Florida Senate and also got him on board. So there was a special appropriations that was made to the clerk of the court and to the Orange County Sheriff's Department to defray the costs so it would not wreck their budgets. So if you know that these costs are going to be involved and you're going to have the lead time on it, if you have state funding, my suggestion is to try to get funding from the state, because if not, it will wreck a local budget.
Our courthouse is all our court employees are county employees. The only people that are state employees are the judges. So we couldn't go to, our legislature meets every 2 years. We didn't have anybody to go to get any additional funding. What we did do in order to defray some of the costs that we had, in our parking area right across the street, which is where we set up the media with the trucks and they had a whole bunch of trucks. We rented out their space. We charged them rent for the spaces. And then we had to run an ISDN line all the way through the courthouse and set up a additional site for them to view the trial. So we charged them for this. And so you look at what costs you can pass along to the media, and that helped for us to defray some of the costs. And by not sequestering them, that also saved us a bunch of money.
Yeah, not sequestering is the answer for us. And then the cost, and there's some extreme costs involved. We're a very large trial court in Maricopa County, so it's the cost of doing business. And we have multiple trials that are high-profile trials going at once, and we just absorb it.
Other questions? Good. One right over here. Here, let's get the mic, please. Should be on the bottom.
And the question, I think, for the recording was, in a small jurisdiction, they have a big trial coming, and the question is, do you let the jurors know ahead of time or right away that this is going to be a high-profile case? And the answer for me is absolutely yes. That's the first thing I tell them. If you hide, they're gonna find out about it by just looking at their phone. And so the first day of jury selection, when we bring them in and I'm screening them just for time, I'm telling them that right away. This is a high-profile case. It will be on television, and we need to have that discussion now. I think you cannot wait. You got to do it right away.
When we sent out our jury questionnaires, it was in the jury questionnaires, so they all knew, I mean, they knew it was State versus O.J. Simpson, so they obviously knew it was going to be a high-profile case. And so we asked them about that in the questionnaire as well. So I'm with Judge Kreamer up front. I mean, there have to be, you would think that even in your jurisdiction, in the newspaper, there's talk about this trial. People are going to know that there's going to be interest. But you, of course, let them know from as early as you can that there's going to be extensive coverage.
Unfortunately for the jurors in Pinellas County, they did not learn about the case until the clerk announced State of Florida versus Casey Anthony, and that was their surprise of the morning.
Okay. More questions? Anyone else? Got one right here.
Thank you. Going back to the questionnaire that has been mentioned, we call it the special questionnaire for those type of cases. Has there been in Arizona any ruling as to if it's confidential or not? In Nevada, you said they reversed it, but Judge Kreamer, has there been any ruling regarding that? Those special questionnaires, are they confidential or are they not?
Well, that's a good question. I was surprised to hear that Judge Glass had to turn them over. I don't think there's been a ruling in Arizona, but I will tell you that we all operate as judges under the impression that they are confidential and we can keep them confidential. And so my assumption's always been that if there's a request, I'm going to turn it down. Now, the media is frequently present during jury selection, and when we're talking to potential jurors, we're talking about answers to some of the questions, and we will give them blank questionnaires so they can see what we asked the jury. But completed questionnaires, we've never given it out. I know we all take the position that the media is not entitled to it. And this has been mentioned before in terms of working with the media and why your relationship with the media is so important. We've had in Maricopa County a very good relationship with the media. And I think part of what is happening here is they are, I think, they understand how important it is for us to keep those confidential. And I don't believe we've gotten a request. I don't know of one. It may have happened, but I don't think we've even gotten a request.
Yeah. Judge Perry, has there been case law in Florida on the confidentiality of juror questionnaires?
To my knowledge, there have been no case law on that particular issue.
I was gonna say, I will say where there has been case law, most of it has come down on the side of Nevada. I mean, it's following a Supreme Court case, Press Enterprise, that basically said that anything that's part of voir dire is part of the trial, so it's open trial. And so unless the judge is making a special decision to redact part of the questionnaires, then it's fair game and usually open.
Or articulate specific, very specific reasons why you're not going to let those go. I mean, very specific. And if you have any issues, I urge you to go online, because it's linked up to the website, and take a look at that case. One of the things that all three of us all agreed upon earlier in our earlier session, and one thing I think we would like to impart to you is, as a judge who is sitting in one of these cases, one of the most important things in order to get through this experience kind of in a sane frame of mind, don't watch TV, don't read the paper, don't read the blogs, don't go on Twitter, and don't go on Facebook. And as Judge Perry said, I said, and you stay in your bubble. You just put up a bubble and you just don't listen to anything anybody is saying about you. Your eye is you've got to stay focused during an experience like this. You've got so many things that you're managing and things that could pop up. As a judge, I hated being surprised. So, so I like to be have everything planned and have it go. I didn't care what anybody said about me. I didn't care about what they said about my hair, my makeup, the color of my robe. I didn't care. They actually thought I got my hair and makeup done every day for the trial. Wrong. I did not. I did it myself. Seriously. So, I mean, that's what they're paying attention to, folks. I mean, I hate to say it, but stay focused and don't even listen to don't let your friends call you and tell you that they heard what they're saying about you. Stay focused and stay out of that, because otherwise you're going to go crazy. And you really do have to stay focused and on your job and what you're doing and getting to the end of that trial with that jury intact. Like Judge Perry, I did not lose any jurors. Now, Judge Kreamer, he has a reputation. And he can tell you about that, but you really do have to stay focused and stay off any kind of media to get through this.
And we are out of time. So thank you all very much, and thanks to our panelists.